Welcome to All Things Work. I'm your host, Ann Sparacco. So here's a startling statistic for employers. In 2023, the U.S. Equal Employment Opportunity Commission, or EEOC, as you may know, secured a record $665 million for workers through litigation. And some of the most common types of lawsuits included those related to discrimination, harassment, wrongful termination, and overtime pay. Now, of course, no employer or employee really wants to ever experience a situation like this, but clearly they're happening quite a lot. So today on All Things Work, we're joined by Mario Bordogna, who has really studied the ins and outs of these kinds of lawsuits as a partner at Bowles Rice LLP. So welcome to All Things Work, Mario.
Thank you, Ann. It's so great to be here. We're looking forward to our conversation.
Yeah, we're really excited to get your knowledge on this subject because we know it can get complicated. So, fun fact, Mario recently spoke at our SHRM 25 conference where he counted down the top reasons why employers get sued by employees. And he gave attendees great advice for avoiding them, which is great. And now we're bringing some of his expert insights to you, our All Things Work audience. Even though none of these scenarios are fun when handled in the real world, as we have to admit, today we're going to have a little fun in the episode with a new format with the way we approach them. So I'd love for you to help us frame where we are in 2025 with employment lawsuits. They've been around forever. We know this is not the new part, but what actually makes them more likely to happen now, or what makes them more of a risk or danger than they really have been in the past?
It's a great question, Ann. And I think one of the main reasons why, when I've given this presentation before, it's so many people take interest in it. And I think there's some common threads. We'll talk about those. They'll reveal themselves throughout the course of the day today. But I also think the risks are different and greater than they're ever before. And I think one of the reasons why is, you've seen some changes with the workforce, the type of people that are entering into the workforce, the demographics of the workforce. That's been a huge shift in change in attitude and approach for what people expect out of work. And COVID, of course, even though it seems like a long time ago, I mean, you speak about these types of topics with so many people on a consistent basis. I mean, that was such a seismic jolt to all things work and the way everybody does work, the way they approach work and they think about work. And I think those things have caused compliance issues and needs to rise and be more important for employers to manage properly more than ever before. I mean, I think those are some of the big reasons why we're still out here kind of talking about this, and even with heightened urgency more than ever before.
Exactly. It's very complex, but we'll try to simplify it as best we can for our audience today, especially with your expertise. You're going to help break it down in a fun way. So I would love to jump into our scenarios here. I'm going to describe 5 situations that our real workplace leaders face, and then give you 3 choices for what to do next in the ABC style, as you will. So you'll be able to make your choice and tell us why that's the best path with the least risk for employers. So ready to dive in?
I'm ready. Fantastic.
Okay, so scenario number 1, a manager wants to fire one of their employees with a history of poor attendance and even interpersonal issues, but their personnel file contains only positive reviews with no documentation of issues. Real conundrum here, and this is a real life issue here. So the next choices could be A, terminate the employee immediately, hope for the best. Begin documenting issues, but still plan to terminate the employee in a month or so regardless. Or C, meet with the employee to discuss concerns and set clear expectations, then evaluate performance, document, and act as necessary going forward. Thanks,
So
pretty clear.
you're starting off easy is what you're
I
telling
know,
me,
we gave
right?
the easy one to our audience.
Right, Ann? So, well, I think, first of all, I mean, hope is definitely not a strategy when it comes to workforce compliance. So we don't want to do that. I think that was one of the earlier answers. But I think the best approach there is probably the last one you outlined, Ann, which, involves meeting with the employee to kind of go over those concerns and set the right expectations, and then, then evaluate that. Okay. And you're more acutely and properly tracking that then forward. That sets your baseline for, if there is employment action that you're actually going to formally walk through, then you've set a baseline to kind of better protect yourself, protect the organization from this legal risk going forward, at least better position yourself. I think sometimes employers who see this scenario, it's immensely common. We could talk, and I'm sure you have before, about managers and how they handle performance appraisals and whether they're good at that, not good at that. But this scenario still comes up a lot. I think when HR professionals in particular see it, they get flummoxed by it. They hear what the managers told them about the performance not being great, and they expect there to be a documentary record of that which supports it, right? But when they go to look, it's not there, and they're surprised. They think, well, what have you been doing? Have you been coaching this employee? Have you been setting those expectations and working forward with that? So it's really a better place for employers to try and set that square. In fact, and I've told them, and HR professionals too, that if you start to see this come up in your workplace with your managers or with your supervisors, make it a prerequisite before you'll sign off on separating anyone, that this documentation be there in the file first before you go forward. And that will help better train and culture your supervisors to adopt that way of thinking and set forth a better process in place, to make it cleaner, if you will, when you need to walk through a separation or some type of employment action like that.
Awesome. And thank you for walking us through just kind of why this would work and why the other options wouldn't work. Like you said, hope is not a strategy. So don't rely on that, people. The first one was an easy one. Come on, guys. Let's get a little tougher. We got number 2. An employer submits a doctor's note requesting a workplace accommodation due to a medical condition. We know this can get tricky. The note is vague and their manager is unsure how to proceed. This is tough. So the employer can meet with the employee to review their essential job functions and clarify their needs. B, request additional medical documentation before taking further action. Or C, consider whether the request creates too much hardship or puts the employee or others at risk.
That one's super.
Yeah.
This is and I hope the audience listened to those options closely, because actually, and rather than select one of those, all three really are what an employer should do here.
Trick question.
Yeah, it's we're already flipping things a little bit for our audience here, but yeah, if you're a manager, you're a supervisor, or you're an employer, an HR professional dealing with something like this, and you get that request for accommodation, but it's not complete, or the manager's not sure how to proceed. I mean, really, there are a core set of steps that most employers should follow, and really, you kind of outlined them all, of talking with the employee first to get a sense for what their needs are, go over the job and the essential job functions of it. Be sure that you get all of the medical information that you need about that. Sometimes, I think, like you alluded to, and sometimes you'll get that from the employer. The employer will get something that it's not complete. It's not enough. It doesn't answer the necessary questions to allow the employer to determine, is there a reasonable accommodation here we can provide our employee? And that's what you should want to do if you can. I think that's a great starting point. And then, of course, there are those, they're not catch-alls, but they're exceptions, maybe, if you will. If there's a particular degree of hardship for the employer, the bar for that has to be high, in the realm of legal scrutiny, or if there is a possible accommodating the employee as is being sought, could be a threat to that employee or others. That's a consideration too. I mean, so all of those things, it's almost like having a checklist, if you will. If you're in this space and you do this a lot, if you have that checklist and guide, whether you're HR and you do it, or whether you delegate that to the frontline supervisors and managers you have, I think going through all of those things is crucial to help the employer ward off, some adverse claim coming their way before. Walk through this the right way, step by step up front. You have to take your time with it, and you have to be thorough with it. But honestly, I want to peek ahead to where we may wrap up with this discussion once we've gone through all these scenarios, but process is really important. And I think if employers are able to get that right, and walk through all of these things here with an accommodation scenario, they're really positioning themselves better off.
Right. So D, all the above. And, there's no one perfect way of doing this. There can be multiple ways of how to do or multiple steps that you can take. So in this specific scenario and in other scenarios as well. So that's a good lesson to keep in mind. And so on to scenario number 3. An employee files a harassment complaint with HR against their manager, woof, saying, quote, "I'm not sure if I'm overreacting, but they're making me dread coming to work." This is their first complaint, and their manager is high performing. Tough one here. Okay, so the next steps could be A, tell the employee you'll look into it, but wait to see if more complaints surface before taking action. B, begin an investigation immediately by interviewing the employee and manager separately and documenting all details. Or C, inform the manager about the complaint and ask him or her to avoid the employee until things settle down.
Wow. This is a big one for
It is.
employers. Um, fantastic choices there, Anne. I think that, and I'm looking at the scenarios. This is not a D all the above question. I
Right.
think this one is. I think this one we're hitting this one for the audience a little straighter. I think this one's definitely B. I think that this scenario talks about investigation, mistakes or common investigation errors that employers make, and those are frequent. But I do think if you get a complaint like this, you do want to take it seriously. I think that's problem number one. A lot of times, as employers or HR professionals don't always do that. They may be well intended, but sometimes they're not sure what to do. This scenario you raised, Anne, in particular, has that tricky element about a high performing manager or supervisor, which is within the organization, there are some challenging variables or optics that go into that. But as an employer, we talk about process and the need to do that. I would tell you, look, if those are some of your potential actors, then the risk is that much greater. It mandates the need to take the appropriate steps, even more so. And I think that's probably B here in this scenario where you're beginning an investigation immediately, and talking with the complainant about the concern, and even talking about the manager separately. These are investigations that employers need to take. I've talked over the years many times about this subject specifically and how to do that. And they're fraught with you either don't start it or you start too slow or you don't do it thoroughly. I mean, really, the pitfalls are everywhere and all around and closing it when you get something like this. So once again, you do have to start that. I think if you don't do that in general, you're asking for trouble. If you don't do that in this specific situation, as hard as it is,
Hmm.
given the potential actor involved, you're really asking for trouble. There was a
Right.
case that I read about the other day, Ann, that had to do with a harassment complaint. I think it was a case in Nebraska, where the employer, tasked HR with kind of investigating that, and they didn't do that quickly or thoroughly, and didn't talk to everyone involved. They didn't do things like when the investigation was concluded, circle back with the complainant, okay, or update them on what's going on. I mean, if those things ever end up in a lawsuit or end up, in front of a jury as a result of that, these optical things really look bad. I can, I can tell you 2.5 million reasons came out of that case as to why employers need to get this right. And that was just one that I read recently. So there are many of those scenarios. Employers confront them a lot, particularly with harassment complaints. And so you have to recognize when you have a situation you need to look into. And like you outlined, I think in the second option there, start it well. You can't, wait to see if more complaints come in. You can't hope things will settle down. Again, hope's not a strategy, right? We're revisiting that one already. So you really have to roll your sleeves up, and it takes, in fairness to everyone out here who's doing this great work. And again, this podcast, you fantastically talk to so many people about that. It isn't always a one size fits all. And it does take I think some experience to know when to do that, when to jump in, when to start, um, who the right investigator is, all of those variables. But investigation mistakes are one of the big things that ultimately land employers in hot water, and it can look bad, when you do later. So it's really important to button them up.
And in addition to, doing the hard work, rolling your sleeves up, you dance around the sense of urgency. I think that's a big part of the point you're making, is because if you don't address it immediately, you're leaving this gap for other problems to occur. Maybe like you said, if it's not documented right away, there could be things that happen in between, and then you're left trying to clean up that mess in addition to it. So you're almost creating more work for yourself with a lack of urgency, right?
There's no doubt about that. One particular thing about harassment investigations and complaints that you get, sometimes they're made in isolation, sometimes they're one-on-one scenarios. But when you talk about how things can get worse, one of the big ways things can get worse in this area is, other workers are watching. They're paying attention for your response. Sometimes they know about it. Sometimes they've seen it. They have seen it themselves from a distance, and maybe they haven't said anything. And employers, are right and wise to try and put all of their workers through training to recognize when to report these things. And bystander training is more important than it ever was. But they see this a lot. And even though they may not say anything, if you as an employer are silent or slow in responding, not only are you creating legal risks for yourself, but honestly, you're creating an unhealthy work environment or culture that they're paying attention to. I mean, the intangible consequences of that are, they may not be quite as upfront and tangible as you might think, but they mean an awful lot as well. So you are creating more for yourself if you just sit by idly and hope it goes away or wait for other complaints.
And let's also be realistic here. By the time someone actually does report to HR, they've had conversations about this issue, either with another colleague, whether that be a mentor or someone else, in order to navigate it. Because not everybody easily just goes straight to HR, keeps it confidential. If we're being realistic, the average human being, the average employee, will seek advice from someone else or make it clear there's an issue before even approaching HR. So the conversations are happening that's impacting your workplace culture as well. So double the sense of urgency if you can.
Absolutely. You are spot on with that. I mean, there's
Right.
no doubt about that. That's probably the more common way they deal with these things. And that's if they
Mhm.
haven't already consulted with a lawyer about the situation. So
That as well. That as well. They're always trying to, make sure they're, on top of it. So that's good things to keep in mind. Thank you for that. I would love to jump into scenario number 4, so we're not lingering too much.
let's go.
So think of this situation: an employee notices their paycheck is missing overtime pay. Payroll realizes the error affects several employees due to a recent system update. We know that this can happen. So here are a few options. They can fix the employee's pay, but monitor if other employees report issues before investigating further. Tell the employees the issue will be fixed in the next regular pay cycle. Can't promise that. Okay. Or C, sorry, I'm giving away the answers. C, immediately review all affected employees' time records, correct the errors, and issue supplemental payments. Sorry, I'm jumping ahead. I get too
You
excited
love
about
it.
this.
That's all right. It's awesome. All right. So which of these? Yeah, I think in this situation, if I were leading the payroll team, or HR consulted me, Mario, we just noticed we had a pay error, or potentially a pay error that affected more than one group or more than one department. What should I do? And I think that, yeah, I mean, undertake the last option there, number C, is probably the right way to go here. I mean, you really have to dive into that right away. It's roll up your sleeve work. It's detailed work to assess, well, who's affected? Okay, how they were affected, and how often. Is it every week? Is it's been going on for a month? And be sure, that when you're doing that sort of sudden audit, for lack of a better way of putting it, right? You got to do that right. You have to figure out what may have been inappropriately paid, and realistically, you really should issue those promptly. One of the issues that employers deal with a lot is I'll tell them that, and just like kind of you walk through there in that last option, and they'll say, Mario, that sounds great, but isn't that going to get us into trouble? That's going to send a message to the employees that we screwed up. How do we do that? How do we best go about that? And I think they that reluctance that they have about that often is an additional obstacle. And so working on the messaging of that is something that's important as well. It's not easy. It's not clean. But one thing you don't want to do with wage issues is let them linger, because
Yeah.
the longer they linger, the more the penalty can grow. And on top of that, the more systemic they can be. Because if
Mhm.
you do it with one person and you have 100 people doing that job, subject to the same payroll functions and calculations, you probably are looking at a much bigger problem than that. You may have talked with other guests, and your audience may have listened to it in the past. Kronos had a pay hack. That's a common, provider of payroll services that a lot of employers rely on, and they depend on the third party to manage that. And they had that hack, and it affected payroll, and you had a lot of issues which came up from those errors that employers are still dealing with today. Some of that much bigger, much more substantive. So if you see one like the scenario you outlined, Dan, where you realize it in short course, you want to try to fix that, correct that, nip that in the bud, and move on. And it's also a greater sign that maybe once you get through that, you might want to have someone take a bigger look at some of the pay practices as a whole, right? Some of the other things, sometimes where there's smoke, there's fire with pay. And you don't, it's, when I talk about this issue in front of audiences, and I did it at SHRM, but let me introduce you to the concept of a class action, or, and punitive damages and things like that. So very dangerous stuff legally that employers need to be on top of. If you see a scenario like that, definitely tackle it right away.
Okay, fifth and final scenario. A covered employee with a serious health condition exhausts their FMLA leave but still cannot return to work. We've talked about this specific situation actually on other episodes before in the past, and it's always thought provoking. So the next step choices could be: A, review any other leave options provided by your employer or by law and assess whether their condition qualifies as a disability under the ADA. B, terminate their employment even though you really love having them on your team. C, out of the goodness of your heart, let them continue to be on paid leave until their condition improves while hiring a temporary replacement to do the work in the interim. Now, this is a tough one because you feel emotionally attached to this. You understand that person's going through something, and then you have to balance that legal landscape there.
Yeah, it is a tough one, and I'm not surprised that you've talked about it with others. This one does come up a great deal, and I think of the options that you outlined, and I think C, the last one, is the way to go here. Okay, no, I'm sorry. It wasn't the last one; it was the first one,
Yeah.
where you're going to, yeah, because what you need to do as an employer, really, and this is where I think they misstep with this, is you have to remember that you're not in a vacuum with this. You're not just dealing with possibly a condition that's protected by one area of the law or the ADA or something like that. So when you have a scenario like this where someone is out already having one form of leave, it's easy to overlook the fact that even if that doesn't apply anymore or it ends, you're not necessarily done. There might be several things going on at one time. It might qualify for other protection. It might qualify for protection under state law or your own policy. So really, what I best recommend employers do when they have a situation that comes to them for the first time, they really need to evaluate it through all those lenses and start to think ahead about which of these, if one were to stop, is it possible that another one might still cover and provide benefits to this employee? Because as much as employers sometimes work their best to be sympathetic, they have a business to run also. They have a position that has gone maybe unfilled or unworked for a period of time that can only go on for so long. So they're starting to run through all of these, what are we going to do scenarios in their head? Hire a replacement temporarily, then what when the person comes back? All these things. But as a fundamental way of going about it, you really need to be mindful of the fact that certain reasons or conditions for leave are covered under multiple laws, and not just laws, federal, state, and local, but also maybe even your own policies. How many employers or others you talk to, and over these many other fantastic episodes have talked with you about the paid leave that they provide for their employers. I mean, we still don't have a national paid leave program, but more employers are doing that, since we're the only pretty much civilized nation without something like that. So we do see that a lot, and employers need to be mindful of all of those sources of sort of protection or rights, because if they don't, again, this is a common scenario, those lawsuits will come and you get tripped up over that.
And I would love to wrap up with this. We talked about a lot of different scenarios. We know there are so many more scenarios out there. Out of the ones we actually brought up, what's been the most common that you've seen in your over 2 decades of your career in employment law?
Yeah, another trick question. Can I say all of them? No,
Oh,
I won't do that. I
not
mean,
really all of the above, people.
yeah, we only have 4 letters or 3 letters here. But honestly, they all are very common. But I think of the ones we discussed, and it's a super question. I think probably the first and the last one. The beginning and end of the list, the leave question we just covered, and then the one at the beginning about the performance appraisals, because that touches so much day-to-day stuff that employers do and supervisors do, evaluating and appraising their workers. I mean, that's a performance review sabotage. That's what I call that situation. But that one is probably among the most common on this list that we've talked about today. And it's amazing how, and even though some of these things, the first one in particular, seems so simple, right? It seems like you shouldn't run into it. It still happens. I still get these calls. So I mean, and it's great to be able to talk here about them, to raise awareness, and keep them in front of mind for HR professionals. So I'd say 1 in 5.
Hey, we're human, and that's why you still have your job, because people need your assistance. They need this guidance. This is the type of work we need in this world. Can you share any final common compliance threads or core best practices employers and their HR teams can use to avoid any type of employment lawsuit that might be knocking on their door?
Yeah. And that's a great question to wrap this up and kind of put a bow on this. And I think, and without saying develop a good relationship with your employment lawyer, I will say some of the foundational things that employers can do to best help them kind of steer clear of some of this stuff, or even some other hiccups they might run into, when it comes to trying to avoid employment lawsuits. One is, I think I maybe mentioned a minute ago, awareness, I think, is such a big thing, right? Listening to, a program like this with all of your audience taking this in, it raises awareness about how these issues come up day to day and keeps them on the radar. That is such a huge part of it. And HR teams need to do that too, training throughout their own staff, everything, their supervisors, their managers. So awareness is a huge big part of it. That's one thing. The second thing would probably be consistency. Consistency in how you tackle these issues as much as possible. Sometimes they vary a little bit, but when it comes to investigations, we talked about that. Have a protocol you'll try to follow. When it comes to ADA accommodations and you get that request, remember that was the trick question where all the answers applied. Have a structure that you try to follow to be consistent. Inconsistency, unfortunately, is the breeding ground for lawsuits. So that'd be the second thing. And if I were to say one other thing, I'd say just consider, aside from things like maintaining good documentation all the time, I'd say honestly, this is difficult for HR people because there's so much on their plate on a consistent basis, and this fire and that fire. But honestly, if you can manage it, I'd say do an HR audit. That is, audit your HR practices. Okay. So things like documentation, things like payroll, things like how often are you trying to square whether your managers are properly accounting for accommodation issues up front when they interact with their people. That takes time and effort, but I can't tell you how valuable it is for having sound practices like that. And so I bet a lot of people haven't heard of that or thought about that, but if you can, I'd say have an HR audit. Those are some kind of common tips or threads, and I think that would help employers a lot in this area, not just with the 5 we talked about, but really some other things too.
Very helpful and a good reminder for our audience as we all get busy in our day-to-day activities to remind yourselves just what the risks are and to be fully aware and stay alert and keep that sense of urgency. So thank you so much, Mario, for your wonderful insight, your guidance, playing this little game with us on the scenarios. We really appreciate your insight.
Can't thank you enough, Ann, and the podcast is fantastic. It was a real pleasure to be a part of it and talk with you today.
Pleasure having you. All right, that's going to do it for this week's episode of All Things Work. Thanks for joining us. We'll catch you next time. If you enjoyed our conversation today, be sure to subscribe wherever you enjoy your podcast so you never miss a new episode. Also, did you know All Things Work is more than a podcast? That's right, we're also a weekly newsletter that includes in-depth articles and the latest research from SHRM to keep you in the know. Just head to shrm.org/allthingswork to sign up. Plus, follow SHRM on social media to view the latest clips and join the conversation on game-changing topics that are redefining the world of work.
SHRM.